When someone you love dies, the grief comes first, and then somehow comes the paperwork. Accounts to close, agencies to notify, deadlines nobody warned you about. I'm Shanty Soerjono with eXp Realty. I specialize in probate and trust real estate here in California, and I walk families through this every week. Before we start, something important. I am a real estate specialist. I am not an attorney, I am not a CPA, and I am not a financial advisor. Everything in this video is general information to help you get organized. It is not legal, tax, or financial advice for your specific situation. Please work with a licensed probate attorney and a tax professional for decisions about your family's estate. With that said, here are 17 things to take care of after a death in California. Number 1. Order 15 to 20 certified death certificates. You can get these from the funeral home or from the county where the death occurred. This sounds like a lot, and it never is. Banks require an original certified copy. Title companies need one to transfer or sell real estate. Life insurance companies require one before they pay out. Investment firms, pension administrators, and government agencies all tend to want their own copy, and they usually will not give it back. Order the extras now. Going back for more later is slower and more expensive. Number 2. Notify the Social Security Administration. If your loved one was receiving Social Security, those payments have to stop. Benefits paid after the date of death often have to be returned, and that can turn into a real headache months later. The funeral home frequently reports the death, but do not assume it was done. Confirm it yourself. And while you are on the phone, ask about survivor benefits, because a surviving spouse or dependent child may qualify. Number 3. Contact the Department of Veterans Affairs if your loved one served. Families miss this one constantly. Depending on service history, the VA may provide a burial allowance, cemetery benefits, a headstone or grave marker, a survivor's pension, or dependency and indemnity compensation. These benefits exist, they are earned, and no one is going to call you to offer them. You have to ask. Number 4, notify Medicare. Let Medicare know the person has passed. This prevents improper payments that later have to be repaid, avoids billing problems down the road, and stops coverage that is no longer needed. Number 5. Contact the former employer. If your loved one was still working or retired from a company, the employer may owe money to the estate. That can include a final paycheck, unused vacation pay, a retirement plan, pension benefits, stock options, or group life insurance. Ask Human Resources directly what is owed and what the beneficiary designations say. Number 6, notify health insurance companies. Cancel coverage that is no longer needed so you stop paying premiums on a policy nobody is using. But be careful here. If there are dependents on that plan, they may qualify for COBRA or another continuation of coverage. Find out before you cancel anything so you do not accidentally leave a spouse or child uninsured. Number 7, contact life insurance companies and file the claims. Do this early. You will generally need a certified death certificate, the policy number, and the beneficiary information. Here is the part that surprises people. Most life insurance proceeds pass directly to the named beneficiary and generally do not go through probate at all, as long as a beneficiary was properly named. That money can arrive relatively quickly, and it is often what keeps a family afloat while the rest of the estate is being sorted out. Number 8, notify the other insurance companies. Homeowners insurance, auto insurance, umbrella policies, long-term care insurance. And if you take one thing from this entire video, take this. If the house is going to sit vacant, call the homeowner's insurance company immediately and tell them. Many policies reduce or completely eliminate coverage once a home has been vacant for a set period. I have seen families lose coverage on the single most valuable asset in the estate without ever knowing it happened. Keep adequate insurance in place until that property is sold or transferred. Number 9, make a complete list of every debt and bill: the mortgage, property taxes, utilities, HOA dues, credit cards, medical bills, personal loans, vehicle loans. In a probate, the personal representative has a duty to identify creditors, and creditors generally have a limited window to file claims, depending on when notice is given and when letters are issued. You cannot manage deadlines you do not know about, so get everything on one list. Number 10. Inventory all of the estate's assets: real estate, bank accounts, vehicles, stocks and bonds, retirement accounts, business interests, jewelry, collectibles, safe deposit boxes. In a California probate, the personal representative is required to prepare an official inventory and appraisal, and most non-cash assets get valued by a court-appointed probate referee, not by you and not by a number you pick. Number 11. Close the credit card accounts, cancel them. This prevents identity theft, stops fraudulent charges, and tells you exactly what balances the estate actually owes. And please hear this: do not start paying estate bills out of your own pocket before you understand what the estate owes and in what order those debts get paid. Well-meaning family members lose real money that way. Number 12. Notify the 3 credit bureaus: Equifax, Experian, and TransUnion. Request a deceased alert on the credit file. The identity of someone who has died is a genuine target for fraud. This one step reduces identity theft, helps prevent fraudulent loans, and stops new accounts from being opened in their name. Number 13. Cancel the driver's license with the California DMV. It is a small task that updates state records and closes another door on identity theft. Number 14. Close the digital accounts: email, Facebook, Instagram, LinkedIn, PayPal, Amazon, eBay, Apple ID and Google accounts, online subscriptions, and do not overlook cryptocurrency wallets, cloud storage, online banking, and password managers. These accounts are not just sentimental. They frequently hold financial information and sometimes real assets that the family would otherwise never find. Number 15. Cancel memberships and automatic payments: Costco, AAA, gym memberships, streaming services, newspapers and magazines, professional associations. The most effective way to catch these is to sit down with the last several bank and credit card statements and look for recurring charges. They quietly drain an estate for months. Number 16. Contact a CPA or tax professional. There may be several returns required: a final individual income tax return, a fiduciary income tax return for the estate if one is needed, and in rare cases, estate tax filings. Just as important, talk with them about the step-up in basis on inherited property, capital gains implications, rental income, and investment accounts. Good tax planning at this stage can save beneficiaries a significant amount of money. Number 17. Contact a California probate attorney. If the estate has to go through probate, an attorney guides the legal process: filing the petition with the court, getting the personal representative appointed, obtaining letters of administration or letters testamentary, giving legal notice to heirs, beneficiaries, and creditors, preparing the inventory and appraisal, paying valid debts and expenses, selling property when appropriate, distributing the assets, and finally, closing the probate. Now, a few California probate facts worth knowing. If the personal representative has full authority under the Independent Administration of Estates Act, they can often sell estate real property without a court confirmation hearing, but they generally must give a notice of proposed action to interested parties. Beneficiaries typically have 15 days to object, or longer if that notice is mailed. If no timely objection is made, the sale can usually proceed without a court hearing. During probate, the personal representative may also have authority to liquidate certain estate assets, bank accounts, vehicles, stocks, or bonds, when the law permits it and it is consistent with their fiduciary duties. And remember, creditors have deadlines to submit claims once proper notice is given. Here is my honest final thought. Handling a loved one's estate is overwhelming, and you are being asked to do it while you are grieving. You do not have to be perfect. You just have to stay organized, protect the assets, and get the right people around you. A probate attorney, a tax professional, and, when real property is involved, someone who genuinely knows probate real estate. One more time, because it matters. This video is general information only. It is not legal, tax, or financial advice, and I am not an attorney or a CPA. Please talk to licensed professionals about your specific situation. If you are an heir or an executor in California and there is a house involved, I offer a free, no-pressure consultation to help you understand where you stand and what happens next. I'm Shanty Soerjono with eXp Realty, and you do not have to figure this out alone.